The requirement for mental capacity for a will to have testamentary effect is stated in Section 3 of the Wills Act 1959, as a will is a creature of the testator's intention to dispose of his property to named beneficiaries upon his death. A testator must have sufficient mental capacity for the testamentary disposition to take effect. This discussion will center around how rigid the courts have been in assessing testamentary capacity for a will to be deemed valid. A person is competent to contract only if they have attained the age of majority, and in general terms the same is true for marriages. Thus, it does not make any sense for the law to allow for minors below the age of majority to have testamentary capacity. This is especially true when there is an automatic revocation of a will when a testator marries, subject to the proviso that the will expressed to be made in contemplation of a marriage shall not be revoked by the solemnization of that marriage contemplated. Therefore, the rigid requirement that the testator be of full age to have testamentary capacity can be said to have practical benefits. In Malaysia, a person attains the age of majority when they turn 18 years of age. Due to the statutory provision in Section 4 of the Wills Act 1959, where it declares that no will made by any person under the age of majority shall be deemed valid, it is compulsory for a testator to attain the age of majority for probate to be granted by the courts. Therefore, the statutory requirement for age is very rigid, as any will executed by a minor under the age of 18 is deemed by the courts to lack testamentary capacity, and Glover says that these statutory restrictions exist for the protection of minors from foolish and premature choices in terms of testamentary decisions. Without mental capacity on the part of a testator, a valid will cannot be created, as there is no basis to determine the testator's testamentary intentions. Per Lord Goddard in the Privy Council case of Judah and Iselin Post, which was cited in the Court of Appeal in To Yau Piu, the mere fact that the testatrix was unwell when she executed her will is a very premature conclusion that she had no testamentary capacity. To displace prima facie testamentary capacity and due execution of a will, mere proof of serious illness was insufficient. Per Justice Gopal Sri Ram, as his lordship was then in To Yau Piu, held that the same test applies regardless of whether the testator has been incapacitated from birth or has suffered impairment of the mind during his lifetime, whether through physical trauma, mental illness, senility, or substance addiction. What has to be shown is that the delusion or mental impairment had an influence on the testamentary disposition, and the illness of the testator so affected his mental faculties as to make him unfit to the task of disposing his property. The test of whether or not a testator has testamentary capacity is derived from Chief Justice Cockburn's judgment in Banks and Goodfellow. Although the testator suffered from insane delusions, his imaginative and distorted grasp of reality, however, did not affect his testamentary capacity, as the delusion did not affect in the way in which he disposed of his property by will. Thus, Banks and Goodfellow established 4 key tests for the determining of testamentary capacity: that the person making the will must understand the nature of the act of making a will, the effect of so doing, the extent of the property disposed of, and appreciate the claims other persons may have upon the estate that he ought to give effect to. Firstly, the testator must understand that the purpose of executing the will is to bequeath his property upon his death, and this will only come into effect on his death and not before, per Justice Gopal Sri Ram, as his lordship was then in the above-mentioned To Yau Piu case. This distinguishes the effect of a will from an inter paribus disposition, where court's assessment of capacity is more flexible, because the donee is still alive and can be examined to determine the validity of the disposition. Furthermore, the testator must comprehend that the will can be revoked and amended any time before his death, and that it is revoked automatically by future nuptials, which are general features of a testamentary disposition. Also, the second limb of the Banks and Goodfellow test, that the testator understands the effect of the will, is to ensure that the testator is fully aware that he is permanently transferring all the proprietary rights of his property to the beneficiary's name in the will, and the role of the executors, who they are, and who gets what in the will. According to Pitts, Courts and Steen, the requisite degree of understanding of the nature of the act will vary from case to case, depending on the complexity of the estate in question, per the principles derived from the case of Rubini. A large and complex disposition of assets that may involve property situated overseas may require a testator to have a higher mental capacity, and conversely, the required degree of understanding of the nature of the act will be much lower if it were a simpler and smaller estate that is being disposed of in the will. In any assessment of capacity, it is essential to establish the testator is aware of the extent of the estate under his control. The testator must be aware of the extent of his interest in the property in which is his to dispose of, and any property of which he or she might only have a limited rights over. For instance, a testator might not be able to comprehend that he only owns half a share in a house that he wants to leave up to his wife upon his passing, because the other half is owned by his brother, and this is evidence that the testator in this instance lacks testamentary capacity. The final limb of the test in Banks and Goodfellow, that it is the testator is supposed to be aware of the potential beneficiaries from his estate to which he ought to give effect, and therefore consider them in the deliberations of who to include and exclude in his will. The final limb of the test in Banks and Goodfellow is that the testator is supposed to be aware of the potential beneficiaries from his estate on which he ought to give effect, and thereafter consider them in his deliberations of who to include and exclude from his will. Offhand, a testator that suffers from dementia and has no recollection of his own family members or friends can be safely be deemed to have no capacity to execute a will. In Batan Singh and Ami Chan, the testator claimed that he had no living relations when he left his property to his creditors in his will. However, he had 3 nephews with whom he had been on good terms. Therefore, there was evidence of incapacity, as he somewhat forgot that they existed when executing the will. However, according to Spalding, while seemingly straightforward, this has served to determine how rational the testator was, and allows the courts to examine the consistency of his decision-making in relation to other persons that he ought to have moral claim to the estate. According to Hedlund, capricious decisions on their own do not point to a lack of mental capacity. The case of Bolton, according to Hedlund, capricious decisions on their own do not point to a lack of mental capacity. The case of Bolton and Knight celebrates the cherished English principle of testamentary freedom, in that a potential beneficiary, however close in kinship, can be consciously excluded from the will for any reason, however frivolous or mean-spirited that reason might be. Nevertheless, there is a strong presumption in favor of any will in which its terms is not unreasonable and shows no sign of mental deficiency. Thus, per Bird and Lucky, the testator need not act in such a manner as to deserve approbation from the prudent, the wise, and the good. This means that a testator has testamentary freedom to give his worldly belongings to anyone he wishes to give to, and can exclude his closest family members from inheriting his property. Clearly, there is no moral obligation to give anything to anyone. However, Purcell suggests that providing reasons for the testamentary intentions demonstrated in the will, if there is an obvious exclusion of close family members that he ought to have given to, shows rationality and the ability of the testator to weigh his thoughts before executing the will. Nevertheless, the discussion thus far have shown that the courts, in determining testamentary capacity of the testator, has been very flexible when it comes to who the testator gives to and who he excludes from the will. The burden of proving testamentary capacity rests on the person alleging the validity of the will per Udham Singh and Inda Kaur, and this person is deemed the propounder of the will. Upon a challenge made to the will's validity because of an alleged lack of testamentary capacity, Order 72 Rule 13 of the Rules of Court 2012 requires the challenger to plead the elements relating to testamentary capacity per the Court of Appeal case of Sajid Singh and Kesa Singh. When a challenge to the will's validity is brought, the initial burden shifts to the propounder of the will to prove that the testator had testamentary capacity, and to dispel suspicious circumstances in the making of the will per the above-mentioned federal court case of Udham Singh. If successfully proven by the propounder of the will, the challenger must thus prove that the testator lacked capacity to execute the will. The court, after examining the whole evidence surrounding the case, must be satisfied that the testator was of sound mind, memory, and understanding at the time of the execution of the will. An impaired mental state is presumed to continue, and thus the testator lacks capacity until there is proof of recovery. Thus, proof must be given that the capacity was regained during a lucid interval in which the will was made. In the matter of the estate of Yusuf Muhammad Saleh Angila, applying the principles from Smith and Tebit, in that the court will need to determine on the balance of probabilities whether or not the testator was lucid at the time the will is executed after a challenge is made on the will's validity based on apparent intermittent lack of capacity. The test of capacity for a revocation of a will remains the same as for the making of a will in accordance with the principles from the case of Sabatini, and if the delusion affects only a section of the will, only that section will be declared invalid per the case of the matter of estate of Borman. Mahendra suggests that when families are in dispute as to the assets of a testator, produced witnesses in court may emerge with plausible though conflicting accounts of the testator's mental state. Therefore, the courts must tread with caution, and a degree of skepticism is essential. To sum up, per the Court of Appeal in To Yau Piu, a very slight testamentary capacity was required by the courts for the making of a will. Faced with an allegation of serious mental illness, the propounder of the will either had to show that the illness was not such as to have caused lack of testamentary capacity, or that the testator had executed the will during a lucid period. In Clancy and Clancy, it was held, applying the exception in Parker and Felgate, that a testator must have had capacity when the will was executed, that the lack of testamentary capacity at the time of the executing of a will did not invalidate that will. This is provided the testator had the capacity when giving instructions on its making. Further, the will was drafted and prepared in the accordance with those instructions, and when executing the will, the testator had been aware he was signing a will and believed it gave effect to those instructions. In Schnell and Simpson, the court stated that the making of a will by an elderly infirm testator ought to be witnessed by a medical practitioner who satisfies himself as to the capacity and understanding of the testator and records in writing his findings as evidentiary proof. Mahindra in another article suggests that it is sensible to involve a medical practitioner who can examine the testator where there is doubt about the capacity by summoning them to witness the will. This has been deemed the golden rule in asserting testamentary capacity. However, per Hughes and Pritchard, prudent as it is, it was not a rule of law affecting the validity of a will, but a recommended practice. Thus, the trial judge would have to evaluate all of the relevant evidence in relation to capacity before determining whether the testator had capacity. It is submitted that this approach in Hughes and Pritchard to disallow the golden rule from being conclusive evidence to an assertion that the testator had capacity when the will was executed can be said to be grounded on public policy reasons. This is so that the rule does not get abused by unscrupulous parties that can prey on infirm testators to benefit from their estate by bringing a medical practitioner who may or may not be impartial to examine the testator, knowing that the courts will be swayed disproportionately by such a step taken. As discussed by Stanley, a post factum medical opinion of an expert to challenge testamentary capacity of the testator, although relevant, is not irrefutable, especially when there is equal weight that can be given by evidence of the involvement of an experienced solicitor in drafting and execution of the will. In the end, it is for the courts alone to perform an evaluative exercise of the evidence as a whole, drawing such inferences that are appropriate and relying on evidential presumptions when they arise. The aging demographics of the world, coupled with an advancement in psychiatric diagnosis, would lead to a higher proportion of the elderly being diagnosed with mental incapacity, according to Lilton, and these challenges to testamentary dispositions are preventable. The Banks and Goodfellow rules are not rigid. They are mere guidelines in assessing testamentary capacity by the courts. However, as discussed earlier, what is certain is that after taking into account all these circumstances and as evidence, the court must be satisfied that the testator possessed sufficient capacity at the time of the execution of the will for the will to carry testamentary effect.